you don't have an attorney and you're about to go to court. My name is Nazarena Hauser, and I am an attorney that practices exclusively family law in the state of Florida. And one of the scariest things that can happen to someone is ending up in court having an actual evidentiary hearing and not having an attorney. So I want to take a few minutes to help everyone out there that finds themselves in this situation so that you understand what it is that you need to really think about, especially ahead of time. If you are going to be dealing with time sharing issues, meaning the amount of time that you have in your parenting plan that a court is about to decide at a hearing or a trial. So the first thing that you need to understand is that depending on whether you are there for an evidentiary hearing or a final trial on the timesharing issues, whoever's motion or petition you are traveling under is the person who's going to go first. So you need to prepare your case knowing that information. So let's say, for example, that you filed a motion asking for temporary timesharing to be determined on your case. If it's your motion, you are the first one who is going to present your case. So you have to figure out what evidence you're going to present, what witnesses you're going to call, and you're going to go first. What happens at the beginning of a hearing is usually our judges give the people an option to do an opening statement, which you should do very briefly if your judge allows you that opportunity. Some judges do not because they already kind of know what's going on in the case and they want to just dive into the testimony itself. If that happens, don't stress about it. That's not a bad thing. But if you do need to make an opening statement, just make it pretty short, make it maybe 1 to 2 minutes, and it should be a synopsis of what is going on in the case, what the testimony is going to reveal, and what you want the judge to do and consider throughout your case. But just keep it very brief. When you are presenting your case, what you need to do is call witnesses. These witnesses need to be able to testify based off of things that they have seen or heard themselves. Remember, the judge is going to treat you as though you are an attorney, even though you're probably not an attorney and you don't have an attorney. You need to know the rules of evidence. So, for example, you cannot put someone on the stand if they're going to testify as to hearsay. That is a very common issue, and the other side will object and it will not come into evidence. So it has to be something that the witness themselves saw or heard. Now, when you're trying to figure out what witnesses you're going to call, make sure that it is relevant to the timesharing issues. In order to do that, in order to figure out what witnesses you're going to call and what evidence you're going to present, you have to be familiar with the statute. You have to go under Chapter 61. You have to go through the best evidence factors because those are the same factors the judge is going to look at to make a determination. Now, fortunately, in the state of Florida, since July of 2023, we have a presumption that equal timesharing is in a child's best interest. So if you want 50-50 timesharing, it is a good starting place and where the judge will start. If you are looking to not have 50-50 timesharing, then you need to look at those factors and you need to determine what witnesses you are going to be able to call to go against those factors. Meaning those factors have to be something that the other parent has failed to do. For example, one of those factors is if there's any evidence of alcohol or drugs or domestic violence is another one. So those are things you need to look at. And if you don't want 50-50 timesharing, you need to have your witnesses and evidence lined up to go against those factors. So the first thing you do is you're going to call your witnesses. It is your witness, so you ask them the questions. When you are done asking the questions, the other side has the opportunity to do what's called a cross-examination, meaning they get to ask those questions next that they want to help prove their case and really to make your witnesses probably look bad. So you have to be prepared for that. Now, when you are done calling all of your witnesses, you rest. That's what the judge is going to say is, do you rest? Meaning, are you done presenting your case? You need to know that once you rest and you're done presenting the case, there's no going back. You are done presenting evidence. But what happens next is that the other side then presents their case. They will call their witnesses. They will present their evidence. And you have to be prepared to combat that evidence and that testimony. And so what happens is now the reversed. They call the witness. They ask the questions. You have the opportunity to do a cross-examination of that witness. Now, I want to talk to you a little bit about evidence as well. So you're going to need witnesses that help you introduce evidence. If it is not evidence you could introduce yourself, because you are also a witness. You can take the stand and you Don't obviously ask yourself questions, but you will give your narrative to the judge, and through your narrative, you can introduce evidence. But if you yourself cannot introduce the evidence and you need another witness to do it, you need to make sure that witness is properly prepared to do so. So I will give you a list of different examples that you can use and think about and see if they're applicable in your case. One of the types of evidence that we use would be communications between the two parties, meaning communications between you and the other parent. So if you all do text messages, talking parents, our family wizard, emails, any form of written communication between the two parties is admissible. You just need to make sure you remember to do that. So you would print it out, you would bring it as evidence for the court, and you would introduce it as part of your testimony. So some things that are not admissible would be things like hearsay, something that someone else said at another point. So a police report, right? A police report in and of itself is hearsay. You can't just introduce that document, but what you can do is you can call the officer, the police officer who actually wrote that report. If it's relevant and helpful to you, you can call that police officer under a subpoena to come in and testify on your behalf. And that's how you get the information in that you want through the report. Other examples of evidence that parents frequently use would be videos or photographs. Obviously, you would need the person who was present at the time that video or photograph were taken, and that's the individual that you would need in order to get that evidence submitted into court. So at the end of you presenting your case and the other side presenting their case, you will have the opportunity in some instances to do what's called a closing argument. Again, if the judge gives you the opportunity, great, use it to your advantage. If not, don't argue with the judge about it. They've made a decision that they are not allowing you to do a closing argument for whatever reason. So a closing argument is basically your synopsis of the evidence and why you believe that the judge should rule in your favor based off of the evidence presented. Now, something else that you will need to do is you will need to have filed prior to your hearing a proposed parenting plan. So make sure, it is very, very, very important that you look at the order that the judge issued that gives the instructions on how the hearing will proceed. If there is no order from a judge outlining the things that need to be done prior to the hearing, go onto the judge's website, look at their procedures, see what they expect out of you. Those are things that we as attorneys do regardless in all cases. You need to know what the judge expects of you. Look for the order, look for the judge's procedures, follow those, make sure you meet all your deadlines. You're going to have a deadline on when your witness list is due. You're going to have a deadline on when your evidence list is due. You're also going to have a deadline on when you need to have your proposed parenting plan filed with the court, and make sure you show that proposed parenting plan to the judge, submit it into evidence, and go through why that proposed parenting plan is what is in the best interest of the child. And if you have any further questions or you need help navigating bits and pieces, we also offer DIY legal coaching. What we do as part of our legal coaching is we guide people who are in court without attorneys. We can draft paperwork for you and you can file it on your own. We can provide you with actual coaching to coach you through how to handle a particular hearing, and we can give you legal advice throughout the way as well.